In late June, our elected officials gathered together for parliamentary procedures. Here to give us a wrap-up and talk about some of the outcomes from that session, we have with us Councillor Austin Harris. Hello, Mr. Harris. Thank you so much for being with us today.
It is a pleasure to be with you, Edlin. Thank you very much for this opportunity.
So 3 days, not a particularly long session for the LA, but would you call it a productive session?
I thought it was an extremely productive session. We reviewed over 14 different laws, made a number of significant amendments to those laws, which we believe at the end of the day will make lives better for the citizens of the Cayman Islands going forward. Some of the amendments are final in the sense that this perhaps will be the last time we'll be making amendments to those laws. Other amendments, particular to border security, others to immigration, some to both the traffic law and others, will be ongoing. Things such as the liquor licensing law will also feature further reviews and revisions in the longer term. But in total, I think we accomplished a great deal in 3 days. And certainly I want to use the opportunity not only to thank the government, but also the opposition for facilitating 3 very serious days of legislative work, but working with the government steadily, diligently, to get the country's business done in the time frame in which we were allotted.
Well, as you mentioned, there were a number of bills that were debated and discussed. So let's kind of get into some of those, because sometimes we can hear about it, but we don't fully understand. So let's start with the Advanced Passenger Information Bill. Talk to us a bit about what changes took place and kind of the thinking behind that.
Certainly. Well, as you know, in the Ministry of Immigration, the long-term goal is to separate the border control functions of immigration from the labor aspect. And the Advanced Passenger Information Bill 2018, which is expected to commence into law shortly, is expected to strengthen both the national security framework of the Cayman Islands as well as the border control security partnerships we have both regionally and internationally. This amendment will facilitate the sharing and checking of advanced passenger information, persons entering the Cayman Islands or departing the Cayman Islands, by referencing those persons against both regional and international offenders lists with the view of identifying persons who may pose a security risk to the Cayman Islands. I think when we look more recently in the headlines of a recent deportee that was recently apprehended by the Immigration Enforcement Department. By having this advanced passenger information ahead of time will allow us to perhaps prevent these potential questionable security risks from ever happening in the first place. So it's a terrific step in the first direction, step in the right direction. Certainly, it also represents for the first time a broader partnership between a Caribbean nation or country with U.S. border and customs security, in particular with the advanced passenger, which will improve efficiency of passengers coming from particularly Miami into the Cayman Islands. So on the one hand, it's about convenience for passengers, not having to stand in lines, not having to sign and fill out so many forms, to have an ease of travel experience, but also on the other hand, to identify security risks that would otherwise cause the country some concern.
So really laying the foundation for the development of this new agency, but also kind of strengthening those ties that we need and that are going to be necessary to really make sure that we're secure and safe.
Absolutely, Edlin. That's exactly correct. Because we are attempting a shift, as we stated, in terms of immigration from a labor aspect and immigration from an aspect of border security, you're absolutely correct. The house is built on a strong foundation, and these initial amendments will provide that foundation on which we will work and grow our plans over the course of our administration.
Another law that was debated, which is separate but very much connected to what we were just talking about, is the immigration bill. Let's discuss that a little bit more.
Yes, the Immigration Amendment Bill 2018 saw 5 rather significant amendments. Part of them deal with, again, setting those important foundations for the new way forward, and the other part were addressing a number of interesting nuances that were identified in the bill. Sometimes you write a law and there are unintended consequences. And no one bill or one law is perfect, but through its operation, you are given opportunities in which to correct certain inadequacies. And in the Immigration Amendment Bill, we see a great many of them. In the first instance, the bill allows for the phased transfer of powers from the Chief Immigration Officer to the Interim Director of Work, which stands for the Workforce Opportunities Residency Cayman. This will be the agency that will replace the immigration functions that currently immigration is responsible for. It is headed by Interim Director Sharon Rolston. The phased transfer of powers will be those specific to migrant control, such as work permit granting, permanent residence granting, and Cayman status. Now, this one area received a great deal of debate, but it is important when you understand the recent amendment in conjunction with the wider remit of work, which will be to have strategic oversight and planning over our future and current labor market needs. And like it or not, work permits, permanent residence, and status have a lot to do with being able to plan your labor market, both current and future, rather than simply allowing it to happen organically. Because in that mix includes equal opportunity for employment for Caymanians, which again, we acknowledge as a country we've struggled with perhaps since 2007 when we experienced our periods of austerity. The government is still working towards solving that equation, and the Coalition Government of National Unity, one of its goals is to achieve zero unemployment amongst Caymanians. That is, all Caymanians who want to work will find work. This is an important, I think, foundation plank, if you will, a footing in order to achieve the long-term goals that work has set for itself. Secondly, the bill seeks to, again, correct certain anomalies that have existed in previous immigration law. One of those is to better ensure that spouses of Caymanians are treated no less favorably than spouses of permanent residents or Cayman status holders, specifically in terms of gaining naturalization under the British Nationality Act. Previously, again, spouses of Caymanians were allowed the right to work under what is called Residency Employment Rights Certificate, RERC, and that was maintained for a period of 7 years before they could become naturalized and become Caymanian. Now, the thinking at the time was the 7-year window was intended to avoid a problem that is real, and that is marriages of convenience. So how do you determine, what's real and what's not? You apply this timeline. But we very quickly discovered that spouses of permanent residents or Cayman status could very well achieve naturalization a lot sooner than that 7-year window. So now we had to return a degree of balance and equality to the legislation. So the amendment seeks to bring just that, and by removing those timelines so that spouses of Caymanians can in fact be naturalized equally or in the same time frame as spouses of permanent residents or Cayman status holders. Thirdly, and also equally important, the law seeks to alter the eligibility period for elderly caregivers. Persons who are elderly require 24-hour care. We have two choices in this country. Either the family provides a resource or we commit them to one of the residential facilities. Traditionally, and certainly scientifically, elderly persons do better in a home environment. And also as part of the legislation that was passed under the previous administration, the establishment of the Older Persons Law and the Council for Older Persons, the government is cognizant of the needs of the elderly and disabled in the Cayman Islands. So in that vein, the specialist caregivers that were attending to some of our elderly, some of them, in some cases, were exempt from the term limits of 7, 8, and 9 years in the Cayman Islands. But it put a restriction that you had to be employed with that elderly person for a period of 3 years in order to be considered for exemption. We found that in many cases, the caregivers who were providing very important care to our elderly, care that the family certainly appreciated, care that the doctors believed was capable for the needs of that elderly individual. Sometimes they were employed for periods less than 3 years. So the amendment sought to alter that time limit so that in certain special circumstances, caregivers who may have been employed for as little as 1 year may be considered for consideration of exemption. Again, entirely intended to be cognizant of the needs of our elderly and our disabled and to make their lives easier. So that was the third change. The fourth change, again, to address what the media has coined ghost Caymanians. And this is an opportunity to correct a statement that I previously made on another media source prior to the Legislative Assembly, which I actually got wrong in the first instance, but I certainly want to correct it. Previously, children born of either a parent with Cayman status and they were born in the Cayman Islands, they had the right to be Caymanian up until the age of 18. But between the ages of 18 and 24, they had to apply for their right to be Caymanian by entitlement with the Cayman Status Permanent Residency Board. Now, it was a bit of a lacuna because it was an unknown aspect of the law that sort of developed in the media, if you will. But also, the time limits were restrictive. So what the government decided to do was to remove the upper age limit for that right to be Caymanian after they reached the age of 18. So now the child of a permanent resident or a Cayman status holder may apply for the right to be Caymanian by entitlement at any age with the Cayman Status and Permanent Residency Board and be granted that right or that entitlement to be Caymanian. An important aspect of what makes this application to the Immigration Board for the right to be Caymanian is that these persons are not subject to the point system that are included in the permanent resident application process. So again, hoping to correct what we thought were unintended consequences of legislation, hoping to address issues that have been long-standing and a bit of a tidying up process. Fifth and finally, the bill allows for the creation of a separate appellate tribunal to deal with the refusal of asylum claims made by refugees. Under the immigration law, the chief immigration officer has the right to approve or deny applications for asylum. In recent years, we've discovered a concern that there is no tribunal or vehicle in which persons who are denied that right can and perhaps have recourse. So the amendment seeks to establish a separate appellate tribunal which will deal specifically with those asylum applications that have been denied. Again, it is our view that it will improve efficiency, but also improve fairness and equality, and certainly support human rights in the process.
So certainly a law that had a lot of varied changes, some really to establish some ongoing efforts that we have, looking specifically to work in developing that agency, and others, as you said, to kind of right some wrongs.
That's
and
right.
Really kind of demonstrating why our parliamentary procedures are so important, because so many of our laws are really living, breathing documents and have to adjust as time passes on and the needs of the people change.
Indeed.
So moving on to another law that didn't have as many debates and didn't have as many adjustments, the utilities law. Let's talk a bit about the amendments to that law.
Well, this is a bit more, I think, comprehensive in the sense that there were minor adjustments to 5 different utility sector laws. For this, I need my notes. We amended the Utility Regulation and Competition Amendment Bill, the Electricity Sector Regulation Amendment Bill, the Water Sector Regulation Amendment Bill, the Water Authority Amendment Bill, and the Information and Communication Technology Bill. And we did, I think, 3 things here. First of all, in the context of the 5 major sector laws, as you know, we recently implemented and brought into force the Public Authorities Law. The Public Authorities Law is intended to have strategic oversight or considered the paramount law over all operations within public authorities, and that includes the utility sectors. But because the utility sectors are largely made up of a regulatory sector, there were certain verbiage, if you will, within those laws that weren't clear and consistent with the provisions of the Public Authorities Law. So we made minor, largely legalese type of changes to the sector laws so that it recognizes the authority of the Public Authority Law, and whenever there is a question, whether it be from an industry partner or more specifically a question within the courts will fall back on the Public Authorities Law versus the individual sector laws.
So really bringing those things aligned.
That is correct. That is correct. Another minor change is simply to reorganize the role of the authority between that of the board and that of the CEO. Much like in any organization, or certainly in public authorities, the board has the authority to hire and direct the CEO. The CEO, in turn, has the authority to hire and direct their sector leaders. The amendment simply intended to make that provision and those authority boundaries abundantly clear. And third and finally, the amendments to the water regulation law allowed again for the disputes of various water provisions, persons who are either producing water or supplying water, to allow for an avenue for those disputes to be answered and dealt with through the courts. When they fail, perhaps through remediation within the regulator itself, we provided an avenue in which they can, in fact, appeal certain decisions via the courts. And again, we think that is just a way to, not only create greater fairness and balance, but also streamline the business process involved in the water sector itself. Thankfully, we don't have very many challenges in these areas, and I think that is a credit to the industry partners that provide these services in the Cayman Islands. But occasionally, there are a few bumps in the road, and this seeks to smooth things out.
Another law that saw a minor adjustment was the Cadet Corps law. What was that adjustment?
Again, each law specific to the leadership of these organizations, they have term limits, much like politicians, much like premiers. They have term limits in terms of how long certain persons can serve in certain positions. The amendment to the Cadet Corps law simply sought to remove the term limit provision on the chairman, allowing that chairman, if he or she wishes, and certainly if it is deemed that the organization is succeeding under his or her leadership, to continue past the prerequisite term limit period. We found, again, based on discussions and engagement with stakeholders, that this was an impediment to the growth of the Cadet Corps, and certainly the ultimate goal is to allow that organization to grow and to fulfill its mandate. But as you know, no organization can operate rudderless. We need a strong leader, and we felt that the revisions were necessary in this instance to remove those provisions.
We also saw some adjustments to the Criminal Procedure Code.
Yes, we made a number of legal amendments to the Criminal Procedure Code, and I'm no lawyer, but this was a bill that was presented by the Honorable Attorney General. It seeks to create consistency in procedures that are observed both in summary court as well as in grand court. One of the examples is, for example, in cases of murder and rape, which are normally dealt by the higher court and grand court. But there may be circumstances attached to that crime of murder and rape, maybe common assault, which would be heard in summary court. The amendments to this section enable both charges to be transferred to the higher court and dealt with at the same time, so you have one trial instead of two trials. So that is, in short, one of the amendments that were made. There were others, one in specific, which again I need to refer to my notes to because I'm no lawyer, but if a Crown has failed to produce sufficient evidence to establish a prima facie case, then the accused must be acquitted at that stage without requiring him to present any evidence on his behalf. However, if the Crown has led a sufficient case and has proven its evidence, and the defendant is then called upon to answer for him or herself, then the court may find, if they are satisfied with the evidence that is presented by the prosecution, and the judge is satisfied with that evidence, then the accused is considered and will be found guilty. Again, this is just applying consistency that is found in the higher court also to the lower court and summary court, so that both courts are operating equally and some would say within due bounds. Again, the conditional release bill or release law has been very useful to us here in the Cayman Islands, obviously, and giving second chances and rehabilitation opportunities to persons who have, committed crimes and are serving their penalties. But there are also, again, certain aspects of that conditional release that perhaps, weren't thought out or thought of at the time of implementation. So it is a growth process. It represents a new law, and like most things, we learn by doing. The amendments, there were two relatively minor amendments. One of those provides the power to the board to reconsider the release of a prisoner who has been authorized to be released on temporary license. Again, the occurrences and the use of this authority are rare, but experience has taught us that there are exceptional circumstances where, again, a decision that was made to release an individual required an opportunity for reconsideration in which the law did not provide for. So now we have that avenue available to the board. Also, it enabled the board to appoint a temporary chairperson. Also provisions that weren't available in the previous iterations. And this simply means that, you have a meeting and you have scheduled members to attend that meeting. Sometimes the chairman or chairperson doesn't attend, but you have the necessary persons to form a quorum. You just need the authority to be able to, amongst ourselves, appoint a chairperson for that meeting. Now this amendment allows for that to occur so that meetings of the Conditional Release Board are not compromised or unnecessarily delayed because of the absence of one person. The more significant amendment to the Conditional Release Bill was to provide whole life tariffs to be applied to persons of serious crimes, whether they be, if they've murdered two or more persons, whether it involves premeditated murder, whether they abducted a victim, whether there was sexual or sadistic conduct involved in that malicious act. This basically means that persons who are charged in these categories must spend their entire life in prison. They're not subject to the 60% conditional release bill, and they are not individuals who will qualify for the release on temporary license aspect that is available to certain offenders. So I think that is a much more significant change, but again, it is intended entirely to protect the public from dangerous offenders. And it's do we wish we didn't have them? Of course we do, but we live in the real world, so we have to make provisions for that. There was a third bill that was also amended by the Attorney General, which was considered a minor amendment, and that was the Law Reform Commission Bill. And this basically entitled the post holder of the Director of Public Prosecutions, whomever that may be in the future, to automatically become a member of the Law Reform Commission. Again, at the present moment, the law did not provide for that automatic membership. Again, the law was amended in order to reflect that.
Shifting to some other topics, it's not quite related to some of the laws we've been discussing, but certainly an important one, and one that certainly got a lot of media coverage, and that's amendments to the traffic bill.
traffic amendment bill saw a number of significant, maybe minor amendments. The reality is a traffic law has seen some 16 different revisions since it was first enacted in 1973. But it's been over 7 years since the law has seen an extensive review. And I think what we saw in the last legislative meeting was the beginning of those reviews, again with the mantra of making the lives of our citizens better as we develop a more modern society. And again, there are certain nuances of the previous law that may be considered draconian or out of date that we needed to amend. Some of the amendments included regulating motorized bicycles as pedal cycles. You know, gone are the days where a bicycle was intended for exercise. Now they have motors on them, and as such, they must be recognized as vehicles, at least in one category. So the amendment allowed for that. From a tourism standpoint, it provided visitor driving permits for those who have been allowed to remain on island for up to 6 months. It also provides persons, again, visitors who may be on island from convention countries, the US, the UK, Europe, to be able to drive on Cayman roads for up to a period of 6 months using their home license, as opposed to having to come in immediately from arriving on our shores to get a license in the Cayman Islands. When it comes down to transferring of vehicles, because you look on the roadways now, they are rife not only with new vehicles, but secondhand vehicles. And one of the problems that the Department of Vehicle and Driver Licensing encountered was that when owners transferred their vehicles to new buyers, there were certain fines that were outstanding that oftentimes owners would simply transfer on to the new buyer. Whether the new buyer was aware of these bills or not remained an outstanding question. So what we did was we amended the law to ensure that owners pay those fines that are in arrears before they're allowed to transfer the vehicles to new owners. So again, making it easier and a bit more fairer so that when you engage in a car sale contract, you know that there aren't any hidden fees or agendas. We also allowed for the reintroduction of mini-mokes. Now, I thought this was a rather interesting inclusion, because a mini-moke was something that I recall as a child bouncing on my father's lap in at 4 or 5 years old. I thought they were terrific vehicles, but for whatever reason they disappeared off the landscape, perhaps for safety reasons, as was argued during the debates. But improvements have been made to the safety protocols of those vehicles. They aren't the mini-mokes of the 1970s. And there have been, again, some representations to have them reintroduced into Cayman society, perhaps as we fulfill some of our longer-term goals. We talk about the revitalization of Georgetown. We talk about some of the projects that are ongoing on the 7 Mile Beach corridor that will enable nature trails and otherwise. These are some of the examples where perhaps the mini-moke may be found useful. They may be governed so that they don't exceed certain miles per hour, and obviously have a specific set of guidelines. But in discussion with the director of the Department of Vehicle and Driver's Licensing, they weren't opposed to the reintroduction of mini-mokes, so we're going to see the return of the mini-moke, which again is a bit of nostalgia, and I'm looking forward to that, actually. Another aspect to the traffic law, which is something that is much more visible to motorists, and that is, of course, the occurrence of the illegal motorcycles and mopeds that are oftentimes seen doing very dangerous stunts on our roadways. The amendment will now allow police constables to seize motorcycles and mopeds that they deem are involved in reckless and dangerous behavior, with the view of hopefully curbing this behavior, which many believe. On the one hand, we all remember what it was to be young, but we never forget what it means to be foolish. And it takes only one foolish decision to result in a fatality or an injury And to, rather than wait for that to happen, we have to be able to give our police constables, again, some teeth and authority when serving and protecting. And we believe this is one of the areas that not only the public support, but we believe will support the Royal Cayman Islands Police Service and their ongoing initiatives. Vehicle licensing. What a chore it is to have to go in and license your vehicle every year, specifically or particularly if it's a new vehicle. What the amendment sought to do was to provide for licensing of vehicles up to 5 years. So if you got a new vehicle bought off the lot, you can go in right now and get that vehicle license for 3 years. But it's believed, because of the way cars are being made these days, the maintenance schedule is such that it allows for provisions to license that vehicle for a maximum of 5 years. And this represents one of those conveniences that we're trying to provide to the general motoring public. Driver's license. Who remembers when your driver's license expires? I don't, and certainly I've been caught out on more than one occasion with hanging on to a driver's license, which I rarely ever use, except perhaps when you travel overseas. You notice, I go, oh my goodness, it's expired. We're now allowed for the expiration to be set on our birth date, because again, motorists and users, through stakeholder feedback, identified what is a date that is easily remembered by everyone: our birthday. So we now included the provision to allow our vehicle licensing, driver's licenses, to expire on our birthday. So every time we get older, maybe it's an opportunity to check our driver's license, make sure it's not out of date, but that way we ensure that all drivers on the road are operating legally. What else? We allowed for the permitting of amphibious all-terrain vehicles to be driven on designated roads. What does this mean? I'm sure we've all seen some of the buses that are both buses on the roadways, but also boats when they want to get around. Previously, there wasn't the provision in order to have these vehicles licensed for general roadway use. We provided the provision so that can happen, so that these vehicles, again, much like the mini-mokes, can be restricted to whether it be off the main road conditions and also governed to maximum speeds, but not denying the creativity of industry or of entrepreneurs in providing a new service in the Cayman Islands. And lastly, it created the framework to allow for the implementation of electric vehicle registration system. Whether it's an electric car, or also to bolster the electronic licensing plates and ID systems. Again, the long-term vision here in all of these provisions is to create a more efficient driving experience, to create a more efficient process of acquiring a driver's license, registering a vehicle, licensing a vehicle, or importing a vehicle. Again, keeping with modern times, whilst providing the modern conveniences to the general motorist, which we believe these amendments will offer.
Right, really, really making life more convenient for drivers, and making sure that it's safe as well too, which is very important and very much needed and very much wanted from the community. There was also some changes to the music and dancing control bill as well.
Yes. There were a number of amendments here, some minor, some may not be considered minor. One of the amendments was to exempt public performances of music for cultural and religious purposes. So a bit of a bending of the rules, if you will, if we have a concert that is promoting a cultural event or an event that is promoting a religious event. Lessening the rules, making it easier for these events to take place. Basically, it's cutting bureaucracy, in a word. It also seeks to permit music and dancing at the airport and the seaport on a Sunday. Again, music and dancing not allowed on a Sunday traditionally, but we want to be more welcoming. to our tourists as they come in. And we have found, again, through stakeholder discussions, that nothing can be more welcoming than steel pans to the arriving passenger who's never been to the Caribbean before, but they associate the Caribbean with steel pans and fruit punch. So this is all part of improving the visitor experience. It also empowers the board to permit music and dancing on a Sunday where New Year's Eve falls on a Saturday. This is a challenge that we almost experienced every single holiday season in terms of, well, what are the rules going to be for New Year's? Will we be able to celebrate New Year's, or will we be restricted? Again, I think the jury is out on this because there's some very strong feelings on both sides of the fence on this argument. But the purpose is, we're a tourism destination. We want to be able to provide that visitor experience. We are dependent on the economic activity for job creation. And again, sometimes this impacts probably one of the most attended times of the years, New Year's Eve. So certain changes needed to be made to correct some of the inefficiencies, and we believe these amendments will work towards that. Also, the last change enables the power to waive fees for occasional and exceptional licenses for events that are part of a national festival. So again, you're a Pirates Week, you're a Badabanu, you want to have a stage performance, but these stage performances generally carry rather selective and sometimes restrictive fees. If we are promoting the island regionally and internationally, if we are promoting a cultural event that benefits locals as well as our visitors, sometimes fees aren't as important as the event itself. So this, again, seeks to smooth the landscape a little bit.
Find some balance as well.
Exactly. Exactly.
Lastly, we're going to be discussing the liquor licensing amendment bill and some of the changes that we saw take place with that.
The liquor licensing amendment bill did a number of things. First and foremost, it provided the opportunity for broader cabinet direction as it relates to the board of the liquor licensing authority. Again, this is to prevent some of the more embarrassing hiccups that were regrettably experienced under the previous board. That, again, we talk about political interference. There's one thing called interference. There's another thing called policy direction that works for everyone. And obviously, we're focusing on the latter. The bill sought to allow Cabinet the authority and the ability to provide broader and more strategic policy direction that seeks to serve the benefit of the whole, as opposed to allow these boards to operate as their own individual fiefdoms and their chairmans and chairpersons as individual kings and queens. So we hope that this will be a learning lesson for us, as all things are, and a way to improve the operation of the liquor licensing going forward. It also increases the power of the Liquor Licensing Board to permit the Sunday opening of licensed premises. Again, this is one of those amendments that cuts both ways, because the level of discussion, particularly in the public domain, has been significant on both sides. The only level of comfort that I seek to offer to the general public is that when these changes were discussed and now implemented, it included discussions with all of the stakeholders. The Cayman Islands Tourism Association, the Department of Tourism, the Cayman Islands Ministers Association, members of industry, as well as taking on the feedback of the wider general public. We talk about jobs. We talk about economic activity. We talk about providing resources and conveniences to our visitors so that we can compete as a regional market. You know, as the now Speaker of the House has been quoted in the past, the Cayman Islands aren't the only pretty girl on the tourism block. We face competition. So to address that competition, but also to address certain need for conveniences, change is necessary. That change is not always easy, but we are confident that with our ongoing engagement with stakeholders, we can help the public better understand why these changes are necessary. These amendments to the liquor licensing are sought to address the more urgent needs that needed to be decided on. It was a decision that nobody wants to make, but you have to make one way or the other. So we sought to deal with that. What we can say, though, to stakeholders, particularly the Ministers Association, members of the wider community, that more extensive changes are planned for the longer term. They will deal with things such as the training of persons who are serving alcoholic beverages, the manner in which alcohol is advertised, and obviously with the overarching goal of ensuring that minors don't have access to alcohol when they shouldn't. Two other deletions were included from the liquor licensing law. The first deletion was for requirements for premises to have plainly marked exits on their license. Now, at face value, that might seem nonsensical, but Section 9 of the law already provides that in order to secure a license to sell intoxicating alcohol, it must be approved suitable by the chief fire officer. Now, we assume the chief fire officer is going to make sure that the sprinklers are in place, that there are fire extinguishers, that there are clearly, visible exit signs. So this was a bit of redundancy that was included in the law that was unnecessary, so we removed that section. Likewise, we removed the section of the law that deleted certain representations made by the chief medical officer relative to smoking. The reason it was removed is because smoking is now prohibited in all public places. So it was kind of redundant to say the Surgeon General warns of smoking, etc., etc. Well, you can't smoke in these locations anymore, so that reference was removed from the liquor licensing bill. So these are reflective of some of the major changes and significant work that I think took place over the course of 3 very grueling days, 12 hours each. There were some very interesting debates. I think the amendments represent what both the Government of National Unity recognized as needed changes. But let's be fair. When we look at the fairness of spouses of Caymanians being able to get naturalized as easy as permanent residents, this was a recommendation that came from the opposition and the member from Savannah, Anthony Eden. And the reason I say that is to say that the traditional combative environment between government and opposition, whilst yes, sometimes it is a necessary evil, but I'm happy to say that in this, what is relatively my fourth meeting since being elected, it's nice to see the collaboration that goes on between the government and the opposition, who all 19 members are elected to serve the people of the Cayman Islands. And these last 3 days were very reflective of the cooperative relationship that can exist between both sides of the aisle and seeking to serve the greater public benefit.
Right, exactly. Ultimately driving for that big goal of making the lives of the people of the Cayman Islands better.
That's correct.
In whatever capacity that is and
that
it needs
correct.
to be. Well, Councillor Harris, thank you so much for joining us. It was, as you said, an extensive 3 days of debate and deliberation. And sometimes we kind of get lost in the details of it all. So it's really nice to get some perspective on those changes and why those changes took place and some of the thinking behind that, and giving us a framework for that. So thank you so much for joining us.
Well, thank you very much, Edlin, for the opportunity. Thank you to GIS for the services it provides. Certainly the government believes that it's important to get the message out, and it's grateful to have the resources of GIS and yourself and the staff members here for enabling that message to get out. Because as you state, 3 days of what seems like a whirlwind legislative session warrants some explanation so that the wider listening audience, the citizens, the residents, understand what their leaders are doing on their behalf.
Thank you again.
Thanks so much.